Continuing case item 25, second appeal 134 of 2022.
Serial
25. Passover case item 20.
कोई डेट टाइम फिक्स्ड है ना, ये लोग दोनों आए हैं। हाँ चलिए वही फेस करो, पास ओवर में कोई करने वाला ही नहीं है।
Item 8. Item 8.
LCR दीजिए। इस दिन तो आप लोगों ने आपका प्रिलिमिनरी सबमिशंस रिकॉर्ड किया था। You can just argue. अब appealant, just kindly refresh.
Yes, my lord, there was a sale of agreement between the plaintiff and the defendant number 1. That is dated 29th of September 2005.
29 डेट बताइए सर।
6/9/2005 को an agreement has been executed.
06/09/2005 agreement between
Agreement for sale between defendant number 1 and plaintiff was
defendant number 1 and plaintiff. Property belongs to defendant number 1.
it was alleged as per the plaintiff case.
That property belongs to defendant number 1. Okay.
Now the plaintiff says that since there is an agreement for sale, therefore the property has to be registered. If they fail to register, then it should be by a specific performance, and therefore this first court has held that since the property is not properly partitioned and there is a posherance, and one party cannot execute sale agreement with respect to entire property, therefore that agreement is not fit for a specific performance, and therefore the suit has been dismissed. The defendant
Just a moment. It was undivided share of the joint family
Undivided
property, or
share.
it was the entire property?
it was the undivided share of the entire property. Plaintiff alleged that there was a amicable partition between the defendants family, therefore it can be enforced by a specific performance. The finding of the first court is that the party, the plaintiff, has failed to prove partition by means and bounds, therefore this cannot be a specific performance of sale of agreement. My lord, this fact which has not been considered by the first appellate court, that there is a already registered deed executed by the defendant number 1, and that is dated 29/5/2006. That is Exhibit C.
This is registered deed,
Registered
sale deed.
sale deed. And
Executed by?
executed by defendant number 1, who was the owner of the interest of the property.
So by this time he claims that the partition was done. He also sold undivided share of his
He sold the undivided share only among families. It is his deed was among the family. Co-sharers. One co-sharer and two other co-sharers.
This was
The plaintiff was a
registered deed.
stranger. Plaintiff was a stranger. He was the tenant in the property.
Okay.
He was paying rent
Defendant number 1 sold to whom?
to wife of
Appellant.
the appellant. The appellant.
Who was defendant number?
Number 3.
Defendant number 3. Who is
Same
the,
family.
Yes. Who is the lordship? Appellant before a lordship.
You see, it is in case of joint family property, there will be a relinquishment deed in favor of somebody.
In this case.
No.
Acha.
In general, if there is a joint family property, one co-sharer can relinquish the share in favor of one or the other member of the joint family. But when there is a sale deed,
It is a sale.
it is a sale deed, it means that there has been some partition sometime.
Interest has been transferred by
Interest
register.
how? How is
The
it?
co-sharer of a joint family property can alienate his share.
Alienation, no, that is
Not-
not a sale deed.
That is sale. Alienation
That
by
is-
sale.
This is an alienation deed.
Yes, that is alienation by sale.
Sale by alienation.
Relinquishment is also an alienation. Sale
That's
is
right.
also an alienation. And this is by way of registered deed. But the suit was filed on 7/6/2006 for a specific performance. The suit was filed on 7/6/2006. My lord, one more glaring fact which is important for a lordship consideration. 19/9/2006 WS filed by defendant number 1. 19/09/2006 WS filed. And there was a mention in para 12 that the deed was executed, that registered deed, 29/5/2006. That is also a requirement in the WS. So it is well within the knowledge of plaintiff on the date when the WS filed. The amendment application was allowed. One amendment was filed by the plaintiff.
Challenging that.
Yes, ma'am.
They challenged the deed.
No.
No, they did not
that
challenge it.
They have a knowledge but they didn't challenge. And therefore my submission in for the lordship, that amendment was allowed 8/9/2008, 8/9/2008. So on that date, even one amendment was there, they could have amended their petition challenging that. But if your lordship may kindly see the first substantial question of law which has been framed in this appeal. Order number 3 dated 2nd of August 2023. Whether the appellate court committed perversity by decreeing the suit of the plaintiff even though as plaintiff knowing very well that the defendant number 1 has sold the suit property to the defendant number 2 by the registered sale deed dated 29/5/2006 marked Exhibit C, yet did not pray for cancellation of divorce. So, once section 54 of the Transfer of Property Act sale completes, then the subsequent purchaser cannot be said to be a bona fide purchaser. And therefore, the decree of a specific performance which is out and out a discretionary relief cannot be granted as a matter of right. And on that basis, your lordship has heard this matter, and your lordship, just paragraph 13, if your lordship may kindly see your lordship's order of Friday, 16th of January, your lordship has taken note of these submissions, and para 14, Learned counsel appearing on behalf of respondent on the other hand has declared and submitted that there was no need to challenge the sale deed such and such as the plaintiff was seeking to enforce the agreement that was also by filing suit on acknowledgement. He has submitted that plaintiff had no knowledge about the sale deed and therefore there was no opinion to challenge. But I was demonstrated, Your Lordship, that they have.
It was a part of the written statement.
It was the part of the statement and the amendment was allowed and they carried out amendment. So it is well within their knowledge. Before that I filed WS and that we had told we have stated this thing. So this is
That's right. Bataiye. What do you have to say on these subsidiary questions?
My lord, I am making from the suit because earlier the suit was filed against the only defendant, my vendor, with whom I executed the registered agreement. My agreement was registered. The agreement of Madan Prasad Gupta, executed on 6/5/2005, was unregistered.
Just a moment. This was 6/9/2005 was unregistered.
Yeah.
You entered into agreement of sale dated?
On 29/5/2006. I'm sorry.
सर डेट में बिल्कुल मत गलत करिए. आप अपना डेट एक जगह नोट कर लीजिए and be very very careful about the date. हाँ बताइए.
6/9/2005, Exhibit 1. This was registered agreement.
You were the plaintiff?
Yes.
All right.
The defendant executed the registered sale deed in favor of Ruby Devi on 29/5/2006. That is Exhibit C. In the plaint, I have filed the suit against Kishore.
This is 29/5/2006 is the sale deed?
Sale deed, Exhibit C.
Exhibit C. 6/9/2005 is Exhibit 1.
Yes, 6/9/2005 is Exhibit 1. That is the registered agreement with me on payment of advance payment of ₹2. Now, unregistered agreement says the agreement was of 9 lakh rupees. There was no payment in that agreement, unregistered agreement. And the Exhibit C executed with ₹4
You
lakh.
have given me the date of registered deed. You have given me the date of registered agreement, that is 6/9/2005.
Yeah. See,
Which is that unregistered deed?
no, unregistered deed is Exhibit B, dated 6/5/2005.
6505 unregistered.
Yes, sir.
This is Exhibit B.
Yes, sir.
Exhibit B was between defendant number 1 and defendant number 4.
Yes, sir. They
And
are
the
the-
sale deed was between defendant number 1 and defendant number 2.
Yes, sir.
So, how is Exhibit C related to Exhibit B?
Exhibit C, actually, this Ruby Devi is the the Madan Prasad Gupta is the father-in-law of Ruby Devi.
It is a sequel to Exhibit B.
It is the exhibit B executed by Kishore Prasad Gupta, the present defendant, in favor of his own brother Madan Prasad Gupta.
Alright, the fact remains that the sale deeds was not challenged.
No,
How do you respond to that?
my lord, in view of the judgment of the Honorable Supreme Court, there are two judgments of the Honorable Supreme Court which say that it does not require to be cancelled. My lord, one is 2024, volume 8, SCC, page 83.
2024, volume 8, SCC, page 23. Para number?
Yes, ma'am. I'm giving that. Para number 20, 22, 24.
20, 22.
In this case, at page 92 of the judgment, my lord, some of the question has been framed by the Honorable Supreme Court, and in which 12.2 D, whether in view of the decision of this court in such and such, the plaintiffs are not entitled to a degree of speech performance in absence of any prayer for cancellation of two subsequent sale deed. This has been discussed in para 22. Para 20, I'm sorry. Now we deal with another argument that the plaintiff ought to have prayed in the suit to cancel the subsequent sale deed executed by the first defendant. On this aspect, the law has been laid down by a bench of 3 honorable judges of this court in Durga Prasad and such and such. In para 40, 41 and 42, it has been discussed and categorically says that no, the Durga Prasad judgment is there also. I have brought it, my lord. In which the matter has been decided and held that in para 22 that B. Vijaya Bharti's case is per incurium in view of Lala Durga Prasad judgment, and in which it is held that it is not required. And para 24, it is categorically mentioned in the judgment that there is no necessity for to pray for cancellation of the subsequent sentence.
Which paragraph of this Lal Durga Prasad?
Para 40, 41, 42.
पढ़िए पढ़िए. Read para 40.
Yes. First, we reach the position that the title to the property has validly passed from the vendor and resides in the subsequent transfer. The sale to him is not void but only voidable at the option of the earlier contract. As the title no longer rests in the vendor, it would be illogical from the convincing point of view to compel him to convey to the plaintiff unless steps are taken to reverse the title in him, either by cancellation of the subsequent sale or by conveyance from the subsequent purchaser to him. We do not know of any case in which a conveyance to the vendor was ordered, but Sulaiman CJ adopted the other course in Kalicharan Singh versus Janak Dev Singh. He directed cancellation of the subsequent sale and conveyance to the plaintiff by the vendor in accordance with contract of sale of which the plaintiff sought sufficient performance as a specific performance. But though this sounds logical, the objection to it is that it might bring in its train complications between the vendor and the subsequent purchaser. There may be covenant in the deed between them which it would be inequitable to disturb by cancellation of their deed. Accordingly, we do not think that it is desirable solution. We are not enamored of the next alternative either, namely convincing by subsequent purchaser alone to the plaintiff. It is true that would have the effect of the vesting the title to the property in the plaintiff, but it might be inequitable to compel the subsequent transferee to enter into terms and covenant in the vendor's agreement with the plaintiff to which he would never have agreed had he been a free agent, and if the original contract is varied by altering or omitting such terms, the court will be remaking the contract a thing it has no power to do, and in any case, it will no longer be specifically enforcing the original contract but another and different one. In our opinion, the proper form of decree is to direct specific purpose of contract between the vendor and the plaintiff and direct the subsequent transferee to join in the conveyance so as to pass on the title which resides in him to the plaintiff. He does not join in any special covenants made between the plaintiff and his vendor. All he does is to pass on his title to the plaintiff. This was the course followed by Calcutta High Court in the matter of such and such and appears to be the English practice. See, Fry and such and such, we direct equity.
So the subsequent purchaser can be directed to execute the sale.
No, my lord. In this case, what has happened that the first agreement was upon which the exhibit C excluded is a sham transaction because according to them, their pleading that there was no partition between the family. Then one part cannot sell the other to the other part. First, if and according to me, our pleading is there that in the year 1995 there was a family arrangement that has been admitted in the WS by both there were two WS files. One is filed by the defendant.
No, don't move away from the point of law. Point of law is that there is a sale deed existing, a registered sale deed.
If it will be held that that was a sham transaction, because
that sale deed, the
transaction,
subsequent transaction of sale deed, registered sale deed, you want to say it was a sham transaction?
first transaction was the sham transaction.
Which transaction? Give me the date. Which transaction do you say is a sham transaction? According to you?
The sale deed exhibit C, that is the transaction made on 29/5/2006 on the basis of exhibit B.
this is the registered sale deed, isn't it? Exhibit C?
Yes,
Yes. So you want to say that this is a sham transaction?
because it is on the basis of Exhibit B. Exhibit B is an agreement that was unregistered.
So therefore, you have not challenged that sale deed.
No, it is not required. I will satisfy on another judgment also. Therefore, I have brought this Durga Prasad's case, that Durga Prasad case held that if there is a sham transaction, then the entire judgment will speak like that, that if it is a sham transaction, then when the decree has been passed in favor of the plaintiff against the defendant number one, then he may be directed to join with me.
That's
And-
right. So you have to make a prayer to that effect, isn't it?
No,
No prayer is required.
no,
Very well.
because why
In
should
whose
he-
favor, you say that there is a sham transaction with defendant number 3.
Yes.
Now you do not want that there should have been a prayer that defendant number 3 should join and execute the sale deed.
I'm coming to the another judgment in which also it is mentioned that I need not in para 40 in this judgment page 24, that is the Maharaj Singh judgment, that is 2024 volume 8 SCC, para 24, the last line may be seen. There is no necessity to pay for cancellation of the subsequent sale deed. Para 24.
Just a moment. Para number 34
20,
of Durga Prasad judgment.
no, of Maharaj Singh.
Yes.
In view of clause B of section
You read para 23 also.
24.
22, 23.
Yes, a bench of honorable judges has rendered this decision. Unfortunately, the attention of the bench was not invited to binding precedent in the form of a decision of larger bench in Durga Prasad. That is what I have cited, 1953 volume 2. Hence, the decision in P. Vijaya Bharati is not a binding precedent. Therefore, there was no requirement to make a prayer in the plain for cancellation or setting aside the subsequent sale deed.
Para 23, please.
Thereafter, paragraph clause A and C of section 19 of the Specific Relief Act read thus. Section 19. Relief against parties and persons claiming under them by subsequent title, except as otherwise provided by this chapter, specific purposes of contract may be enforced against either party thereto, any other person claiming under him by a title arising subsequently to the contract, except a transferee for value who has paid his money in good faith and without notice of the original contract. Any person claiming under a title which, though prior to the contract and known to the plaintiff, might have been displaced by the defendant. In view of clause B of subsection 19, the defendant who are claiming under the same deed excluded after execution of the suit agreement. Excluded after the execution of the suit agreement can be subject to a degree of specific performance as the suit agreement can be enforced specifically against such defendant unless they are bona fide purchaser without the notice of the original contract. When in a given case the defendant who are subsequent purchasers fails to prove that they entered into sale deed in good faith and without notice of the suit agreement, in view of section 19b, a decree for specific performance of contract can be passed against such defendant. Therefore, in such a case, where section 19B is applicable,
Please just hold on. If in a given case, the defendants who are the subsequent purchasers fail to prove that they entered into the sale deed in good faith and without notice of the suit agreement, in view of section 9B, a decree for specific performance can be passed against the defendants, right? So a decree for specific performance can also be passed against the subsequent purchaser. Was there your relief that a decree for subsequent, a decree for specific performance be passed against the subsequent purchaser? Because now, as per this judgment, the sale deed need not be set aside, but the decree for specific performance was to be passed against the defendants, who were the subsequent purchasers.
इसलिए हमें इसको बार-बार पढ़ रहे थे.
But
Paragraph 24. In view of clause B of section 19, the defendants who are claiming under the sale deed executed after the execution of the suit agreement. My agreement was executed and their sale deed has been executed.
yes,
Can be subject to a degree of specific performance as the suit agreement, suit filed by me.
yes,
Therefore, I have filed the suit for specific performance.
only against defendant number 1.
No, but they have joined. Later
They
on, my
have joined
amendment.
later on, but did you change your relief? Your relief was only against defendant number 1.
No, thereafter there
What was your relief?
No, there.
Plaintiff.
I'm coming to the plaintiff, my lord.
Yes,
In the
yes,
plaintiff,
come to the plaintiff.
in the plaintiff, there was an amendment in the house title.
Let us see.
Yes. Very first page, my lord, amendment. Very first page, amendment is mentioned.
ये जो
and
फ्लैट किया हुआ है ना?
Yes. Yes.
देखिए पहले आप प्लेंट खोलिए, उसमें कुछ और भी चीजें थी जो हम लोगों को ऑर्डर करेक्शन करने में भी दिक्कत हो रही थी. टाइटल सूट, राइट?
Yes.
प्रेयर
30
देखिए. Let us see the
36 of
prayer.
2006.
Let us
and-
see your prayer.
On the left portion, my lord, I don't have the order sheet, but on the left portion, there is a house title has been amended.
This cost title has been amended. What
Yes.
about the relief?
Relief was the specific performance contract only. Relief has not been changed. The plaintiff prays for the following relief that on adjudication a decree for specific performance contract be passed in favor of the plaintiff and against the defendant that the defendant be directed to execute a registered sale deed and deed of sale with respect to the suit property house in favor of the plaintiff at the cost of the plaintiff and on payment of balance consideration amount which the plaintiff is ready to pay for and in case of failure of the defendant to execute the required registered deed of sale, this honorable court be pleased to execute the sale. That khas position may be delivered, that the decree for the cost of the suit. And therefore, there are two written statements filed. One is by the defendant number 1 and second is by the defendant number 2 to 5.
Okay.
And in which, in both the written statement, they have accepted that there was a previous partition family arrangement in 1995. The defendant number 2 to 5 explained betterly that we came in possession of the property after family arrangement.
Okay. Now, let us see the findings from the court.
Yes.
You place the judgments. We have seen these judgments that it need not be challenged. So, according to you, this particular cancellation of sale deed was not required to be made in view of these judgments. Okay. What about the second question? Whether the suit property
Well, there is another judgment I may be
for this?
for
Yes.
cancellation of
Okay. Show me which judgment are you referring to?
2022 volume 7 SCC page 384.
Just plus 2022 volume 7.
SCC
Yes.
page 384.
384.
I'm
Any
giving
paragraph?
the copy. I'm giving the copy.
Yes.
Paragraph 5.3 and 16.
Paragraph 5.3 and
16.
this is by respondent. Five point three and 16. Yes, let us see 5.3.
5.3 page 389. It is further submitted that the High Court has also urged in holding that it was necessary for the plaintiff to seek cancellation of sale dated 3/5/2020, executed by defendant number 2 in favor of defendant number 3 and 4, respectively. It is submitted that in a suit for specific performance, it is not necessary for the agreement holder to seek cancellation of sale executed in favor of the subsequent purchaser, and it is sufficient to implead the subsequent purchaser in the suit and seek relief of specific performance against the original owner, and also seek direction to the subsequent purchaser to join in the execution of the sale deed in order to complete convey title to the agreement holder. Reliance is placed upon such as that there were 3, 4, 5 judgments, and thereafter para 60. In this also Durga Prasad case has been considered. In the light of aforesaid factual aspects and finding recorded by the London Trial Court, the decision of this court in Durga Prasad is required to be referred to in para 42. It is observed and held as under, and thereafter that para has been discussed of Durga Prasad case. And before that, I will be permitted to place that statement of in the WSO by both said the original defendant means
No. This point is over.
yes, ma'am.
Okay. Now let us come to the second point.
Yes.
Regarding partition. Read the second question of law.
And the London Council has further submitted that the London Trial Court has given a
No, second question of law. Read the second question of law, friend.
Yes. Yes.
Yes. Read it.
Whether the suit property being a joint family property of the defendant on 6/9/2005, London First Appellate Court committed a perversity by ignoring the fact that defendant number 1 alone was not competent to enter into an agreement for sale with the plaintiff while Exhibit 1 on 6/9/2005 in view of para 14 and 15 of the
There is no question of law framed that the property was not a joint family property. The question of law is, given that it was a joint family property, whether one person could have entered into an agreement. So both the courts have given a finding that it is a joint family property.
No, the trial court said that it is not joint family. It is joint family property.
And what about the appellate court?
Appellate court said that no, it is not the joint family property because there was a family partition in the year 1995 and all the persons came into possession of their share.
Okay, there is a finding by the appellate court. There is a finding by the appellate
Yes,
court
yes.
to that effect.
Yes.
Show me that finding. There is no cross appeal or cross objection to that. If there is a finding that there was a partition then this particular question of law becomes redundant, isn't
Yes,
it?
my lord. Yesterday.
So let us see that finding by the appellate court. They have not filed any cross appeal against that.
Yes, I'm showing the relevant.
Where is the appellate court's judgment on this point? That this point is being reversed by the appellate court.
I'm showing. I'm reading internal page 20.
First, let us see the point of determination. Internal page 7, which was that issue of the learned trial court with regard to partition.
Para 6 it begins in the trial court judgment whether suit is maintainable in its present form, whether the plaintiff has got cause of action for the insurance suit, whether the plaintiff suit is barred by law of limitation, whether plaintiff is entitled to degree for specific performance of one regarding suit length as mentioned in the plaint, whether insurance suit is barred under the provision of Partition Act, whether the agreement for sale executed by defendant in the favor of plaintiff is valid and genuine, whether
Yes.
the plaintiff is entitled for...
Okay, we have seen that. That finding is there at para number 5 at the top.
Yes, para number 5.
Okay.
Whether the agreement for sale that is executed by the defendant in favor of plaintiff is valid and genuine. Actually,
Where is the finding of the appellate court?
yes, finding of the appellate court. Para 7, page 7 of the appellate court. As a matter of fact,
Page 7. Page 7 is not the finding.
no, finding, हम fact में जो
नहीं आप हमको finding बताइए. If there is a concurrent finding on this, then we are not going to disturb it. Otherwise, also there is no question of law as such framed. Where is the finding of the appellate court? Para 16. Para 16, page 26.
Yes, madam. Para 25, page 25. On perusal of the plaint, as well as evidence available on the record, it transpires that the land and house standing over...
Para 16 is not matching. Para 16 of the appellate court's judgment.
As such,
Yes.
from the perusal of the evidence, and that is oral as well as documentary evidence, is transpired that in fact the suit property has been partitioned by the co-sales by an amicable family settlement between co-parcels of the February 117 to 1995, duly signed by all the co-parcels. Further, each co-sharer has assumed its own part and have been paying rent on their respective shares, and partition stands admitted. There was no such understanding between the co-sharers of the suit property that they shall have right of preemption if any one of them ever decided to sell his part of the property. Further, a valid agreement for sale has been entered into between the appellant plaintiff and respondent defendant number 1, Kishore Prasad Gupta, by which the respondent defendant number 1 was under obligation to transfer its share in the property to the appellant plaintiff, in which he was running the grocery shop along with his father. Although the said property was an ancestral property of the respondent defendant, but the same appears to be duly partitioned before the agreement for sale was entered between appellant and the defendant, number one, Kishore Prasad Gupta. Hence, the provisional part of Act would apply in the instant case as admitted the suit property was not only a dwelling house but also a commercial property. It is contended that the learned court below has erroneously decided the issue number 6 and held that the agreement for sale dated 6/9/2005 entered in between the plaintiff and appellant and defendant number 1 respondent was not valid and the joint share in the property cannot be alienated and is without the consent of other co-partners as in spite of the fact that the same property is no more a joint property.
So the appellate court has recorded a clear finding that it was not a joint family property. Correct? And the finding given by the learned trial court has been reversed
Yes.
with respect to issue number 6.
Yes.
And with respect to issue number 6, they have not filed any cross objection or any cross appeal. So this finding of the appellate court has become final against them. Do you get it, Mr. Counsel?
Yes, sir.
This finding that it was not a joint family property has become final against you. There is no cross objection.
Para 6 of the trial court judgment.
No, we will not see that. That finding.
No, that is not the finding. Para
No, para nahi, issue number 6.
हाँ, issue number 7 issue number 5 में जो trial court decide किया है, on going through the evidence of PW1 and 3, I find that the suit property, joint property partition has not been proved by the plaintiff.
आप यहाँ पे देखिए ना पेज 47 का बॉटम में, इंटरनल पेज 8, बॉटम लाइन पढ़िए ये वाला. Considering the oral statement and documentary evidence of the plaintiff, I find that the property is joint property. This finding has been reversed by the appellate court.
The trial court said it is not joint property.
It says it's a joint property.
That is, therefore, I am referring to para 7 of the trial court judgment. Para 7, second line, issue number 5.
Yes.
Partition has not been proved by the plaintiff, nor any registered paper of partition has been produced by the plaintiff from the oral evidence of the defendant and the documents produced by them. It is clear that the suit property is a proportionary property. And your lordship, can you see para 10 of my WS? I have specifically stated that the allegation made in para 7 of the plaintiff are partly correct and partly incorrect. It is true that after family arrangement, the name of all the brothers have been notated in Grady municipality, but in Grady Ranchal office, demand is still
property was a
jointly.
Just a moment. Property being a co-partnership property, it means that it is not a self-acquired property.
Hi, of course.
Right?
Yes.
Since it is not a self-acquired property, was the partition with respect to the co-partnership property was already done.
But,
as per issue number 6.
But we have the defendant number 1 is the only person who has to get this agreement for sale.
So therefore he received that property by virtue of partition, and that was his co-partnership property. It was not his self-acquired property.
Co-partnership property, then interest only so far interest of that co-partner is relevant. Your lordship, this is the judgment where it says. Suit premises found to be joint between two brothers, agreement to sale made by only one of the brother had such agreement of sale is valid and not enforceable.
Finding appellate court ka, it is not a joint family property.
Appellate court ka findings.
फिर?
That is against we are here before the lordship. We are the appellant before the lordship. Lord, the finding of the appellate court disturbed was therefore we filed an appeal. We are challenging the order on 2S4 that the entire case has been pleaded before the lordship as it is a subsequent case. Subsequent purchase nahi hai. This is my first purchase. But dated exhibit C is the first purchase. The second purchase is the execution case. The specific performance decree of a specific performance.
Just let us be very clear on
Yes.
this. The trial court held that it is a joint family property.
It is a co-partnership property.
No, it is a joint family property also. Joint property.
Ah, it is joint property.
Joint property.
Yes.
Right?
Of course.
The appellate court held
Reverse
that
it.
it is not a joint.
It is reverse.
And what is the question of law which is framed? Point number 2.
The question number 2 is whether the suit property being a joint family property of the defendants on 6/9/2005, London First Appellate Court committed a perversity by ignoring the fact that the defendant number 1
Question number 2 is framed as if there is a concurrent finding that it is a joint family property. But there is no such concurrent finding
No,
that
it
it
is
is a
not
joint
concurrent
family
finding.
property.
Therefore, I said the suit was dismissed, appeal was allowed, and therefore we are before the lordship being an appellant. It is a suit for reversal.
That's right.
The issue is only with respect to whether a specific performance of a decree can be passed in respect of a co-personality property on the basis of an agreement which has been executed by one of the co-personal with the plaintiff. And it is not the subsequent sale. Had that been a subsequent sale, the matter would have been otherwise, and Durga Prasad will apply. But this is the case where it was well within knowledge of plaintiff, and plaintiff has filed the suit on 7/6/2006. Before that, so it cannot be said that it is a subsequent. Otherwise, section 53 of transport property will come.
It is subsequent does not mean after the filing of the suit.
Exactly.
Subsequent means after the execution of the deed, whatever
Yes,
it is.
execution of deed.
So
That
there was an agreement of sale, a registered agreement of sale,
Yes.
and subsequently there was a sale,
That is, there was
but to another person.
to another person.
To another person.
Because that was
So
not
these two judgments of Honorable Supreme Court says that the subsequent sale, subsequent to the agreement of sale, right, that need not be prayed to be set aside, and the subsequent purchaser can be made a party to execute the sale.
Nice. Your Lordship, therefore I am saying, your Lordship may kindly see, the prayer is very specific in the suit. The prayer is for a specific performance on defendant number 1, the sole defendant at that time. It is, the amendment was carried out on 8th of June 2000, 8th of September 2008. 8 September 2008. The order of amendment was 8/9/2008, and the amendment was made accordingly. So,
Amendment was made in the House title on 8/5/2007. In the House title. वो पारा 28 जो इंडिया था वो नहीं, यहाँ जो पार्टी बने वो, जिसमें आप पार्टी बने.
that party was in that is what I am saying. It is well within. They have amended the plan twice, thrice, but they have not said these things which I have specifically stated in para 10. And the finding of the appellate court is perverse. In view of
And the direction is to respondent number 1A to 1D.
yes.
There is no direction to the subsequent purchaser to execute the deed, nor there was any such prayer.
No, though they were made party. So therefore, the first substantial question is direct in account. And moreover, Your Lordship, it is a discretionary. Your Lordship knows that the Specific Relief Act may grant a decree of a specific performance. There are certain ifs and buts. Section 12, 16 and section 20 is very specific. So only fact remains. The fact is one. That fact is that there was an agreement. There was an agreement between the defendant and plaintiff. There was an agreement. But that agreement has been unilaterally changed. The conduct of the party is also important in specific performance cases. What they have done in paragraph 20, perhaps in the plaint, they have stated they have deducted 45,000 rupees out of rent from the advance which has been stipulated in the agreement. So that is not permissible. If they are willing and ready, then they should implement their part in toto.
Stick to only question of law that has been.
Yes, this is what I am submitting just to supplement this first two questions, that the deed was in existence and it is well within knowledge. So whether once section 54 of Transfer of Property Act says the sale completed and the interest transfer, then without that is not a Word document. The Exhibit C is not a Word document or Wordable document. So, in case, while it is in existence, can a subsequent sale deed by way of a decree of a specific purpose can be executed, which has been done in this case. So, this is the fact.
Let him come.
Yes.
Mr. Mehta, you just see your decree of the appellate court. There is a decree only against 1A and 1D, 1A to 1D. Who were the defendants, 1A to 1D? That was the original defendant only. There is no direction upon defendant number 2, that is Ruby Devi, to enter into the deed.
नहीं वैसा कोई डायरेक्शन
नहीं है ना डायरेक्शन, प्रेयर ही नहीं है, प्रेयर ही नहीं है. You see, you amended whatever amendment was carried out in 2008. But, okay, you need not challenge the sale deed. Fair enough. But you, even as per the judgments that you have cited, you should have made a prayer that the defendant number 3 should also join in as a co-executor of the deed.
इसीलिए दुर्गा प्रसाद में कहा गया है कि
आप हमको एक बात बता दीजिए मिस्टर मेहता, you just tell us, when there is a sale deed executed by 1A to 1D, as per the decree of the appellate court, there will be two sale deeds in connection with the same property.
Yes, my lord.
कैसे yes कैसे हो सकता है? दुर्गा प्रसाद says that they may join in to execute the deed.
Yes.
Yes, तो joining कैसे होगा? आपका prayer ही नहीं है. Where is your prayer? There is no such prayer.
And moreover,
You just, एक second sir, please. You just have a look at the decree. आप अपना प्लेट में कहाँ amend किए हैं? अभी जो हम लोग पढ़ रहे थे ना, this is what I was pointing out to you. There is no decree of specific performance against what's her name, Ruby Devi or whatever. There is no है ही नहीं, ना है ना हो सकता था, क्योंकि आपका प्रेयर ही नहीं.
No, उसमें भी वो दुर्गा प्रसाद के केस में भी ऐसा ही हुआ था.
ऐसा नहीं है सर, आप प्लीज देखिए, आप ये जो जजमेंट आप साइट किए ना 24 का वॉल्यूम 8 SCC पेज 83, पढ़िए पैरा नंबर 24. Just read para 24. पढ़िए जोर से पढ़िए.
Para 20.
24.
In view of clause B of section 19, the defendant who are
Defendants plural को मत छोड़िए.
Defendants who are claiming under the sale deeds executed after execution of the suit agreement can be subject to a degree of specific performance as the suit agreement can be enforced specifically against such defendants unless they are bona fide purchasers without the notice of the original contract. When in a given case, the defendants who are subsequent purchasers fail to prove that they entered into the sale deed in good faith and without notice of suit agreement, in view of section 19B, a decree for specific performance can be passed against such defendants.
Yes. So suit for specific performance would have been passed against the defendant number 1 and their legal heirs, defendant number 1A to 1D or whatever, and also defendant number 3, to execute the sale deed, irrespective of the fact that the sale deed was not under challenge. But when you amended the suit, okay, you did not challenge the sale deed. Let's assume it's okay. But you did not appropriately amend the relief. And this is the consequence that you have a specific performance only against defendant number 1A to 1B. That is not your relief. For technical है ना sir, specific performance is very technical. एक भी गड़बड़ मतलब पूरा गड़बड़. और वकील साहब अपने दिमाग नहीं लगाए ठीक से तो हम लोग क्या कर सकते हैं? आप लगाइए.
May I say? I am reading the relief portion that the plaintiff prays for following relief. It is not amended anywhere. What has been filed in the suit, it is intact. That on adjudication, a decree for specific performance of contract be passed in favor of the plaintiff and against the defendant.
That was the original relief.
Yes, yes.
इसीलिए आपका जो appellate court का डिक्री है ना, सिर्फ 1A to 1D को ही है. And you just see the appellate court decree. It is not against all the defendants or all the concerned defendants who would have become party to the execution of the deed.
It is in the first appellate court judgment. It has been held that there was a previous partition on the basis of family arrangement. Therefore, he, the Kishori Prasad Gupta, is entitled to exclude the sale deed.
Fair enough.
Therefore, direction has been given to him on the basis of the relief.
How will he do it? Because he has already executed the sale deed with respect to the same property in favor of defendant number 3. How will he do it?
But according to the conduct of the parties, it is in view of the conduct, because it was my agreement is registered, their agreement is unregistered. Thereafter,
Is there any finding apart from this? ये तो हम लोग improve नहीं कर सकते, इसमें तो judgment ही
Yes.
देना पड़ेगा, ठीक है? Apart from the other, is there any finding that the subsequent sale deed was not in good faith or they had knowledge about it? Is there any finding to that effect?
yes, one.
Finding दिखाइए, finding. I just want to see the finding.
Judgment paragraph 24.
Para 24 of page
Page 24 of the appellate.
Page 20. Yes.
Second paragraph. DW2 Sunil Prasad Gupta. It is dependent witness.
Page number 24, internal page 17.
Yes. Admitted the DW2 has admitted.
सर वहाँ तक पहुँचे नहीं, आप कहाँ पर पढ़ रहे हैं बताइए?
Appellate court judgment running page 24.
Internal page बताइए.
Internal page 24.
24.
Yes.
Appellate court judgment, internal page 24. DW2 Sunil Prasad Gupta.
He stated in his evidence that the defendant of the instant case, Kishore Prasad Gupta and Mother Prasad Gupta, are his own brothers, and further he stated the same fact as stated by defendant DW1 during the course of evidence. But by para 24 of his procedural examination, DW2 has admitted the fact that the land was sold after mutual consent of all the brothers, and further by para 25 he has admitted the fact that the agreement entered into between the plaintiff and defendant was also made after mutual consent. Thereafter, after two pages, that is running page 26, internal page 26. In the middle paragraph, DW2 has admitted the fact that the land was sold after mutual consent of all the brothers, and further by para 25.
सर आप कहाँ चले गए? नहीं पता चल रहा है. Where are you? Page number 25, internal page 25.
The internal page 26.
26. दो पन्ना.
Page 25 also there, my lord.
आप
Middle
एक
paragraph.
पेज से दूसरे पेज में मत DW2 has admitted the fact that the land was sold after mutual consent of all the brothers, and further by para 25 he has admitted the fact that the agreement entered into plaintiff and the defendant
Also
was
made
also
after
made
mutual
after
consent.
mutual consent. तो सर आप हमको बताइए कि how do we how do you get out of the decree passed by the appellate court, wherein only one of the defendants had been asked to execute the sale deed?
Actually, I was in possession of the property from the very beginning. And when the sale deed was executed recently by the order of the court, it is court who has executed the sale deed in favor of the plaintiff. Nobody came forward to execute the sale deed. Now, two deeds are there that I admit. That with regard to one property, two deeds are there. But my position is there since last 82. In view of the judgment, I am entitled to get the property. This property executed
In
as
view of the judgment, defendant number 1 and a plaintiff is entitled to get the property.
yes,
Yes.
this is entitled to get the deed in his favor.
Yes.
That has already been done
But
Now-
executed by whom?
by the court.
No, court has not executed it. You see, there is a direction to the plaintiff to execute. There is a direction to the defendant number 1 or their legal heirs to execute the sale deed, right? If they do not do it, the court will
Court
do it
will.
on their behalf.
Yes, yes.
But there is neither any direction nor any possibility that defendant number 3 would also join in the execution of the deed, because your plaint was not amended accordingly. You didn't amend the plaint.
Well, I want to see judgment more, my lord.
नहीं अब नहीं हम आपका सुन रहे हैं.
Otherwise, Durga Prasad judgment is in detail. It has been.
आप भी सुन लिए.
एक पैराग्राफ एक लाइन
नहीं एक सेकंड
जी.
हम सुन लेंगे आपकी
जी.
बात. लेकिन आप लोग थोड़ा रिटन सबमिशंस दे देंगे क्योंकि कुछ चीजें ऐसी आई हैं
जी.
ड्यूरिंग द कोर्स ऑफ आर्गुमेंट
जी.
व्हिच यू नीड टू मीट. इफ यू
जी.
वांट टू मीट इट बाय अ जजमेंट प्लीज गिव इट 2 दिन में. इससे ज्यादा टाइम नहीं दे सकते.
Monday को देते हैं, my lord. Otherwise,
नहीं तो मत दीजिए ना. हम तो सुन लिए आपको. आई डोंट नीड इट. मेरे पास तो यूट्यूब में सब रिकॉर्डेड है. हम तो अपना रिकॉर्डिंग सुन के डिसाइड कर लेते हैं. आई डोंट नीड. Because you said that you want to cite some judgment या whatever. ऐसे हमको memory में नहीं रहेगा, Mr. Mehta. It is not possible to remember everything. हमको कोई हमारा तो सारा recorded है, तो हम तो जाके I revisit at times.
No,
जहाँ को
I
confusion
know
होता
that
है.
while passing the judgment, my lord is to exercise much better than us.
तो इसीलिए हम ऐसा नहीं चाहते हैं कि हम आपको कुछ ऐसा कोई ऐसा जजमेंट आपका साइट होने से छूट जाए या कुछ. But if you want to give something in writing, you can give. But it is a very, very technical
They have
point.
to do. They have to do.
तो ठीक
Citation I
है.
will give. Otherwise, written
आप दे
submission.
दीजिए, हम आपका हम ऑर्डर तो रिजर्व कर लेंगे, हम फर्दर आर्गुमेंट नहीं
बस
करेंगे.
1 मिनट का समय दीजिए. ऑर्डर जनरल सेक्शन 20 हम रेफर करेंगे स्पेसिफिक.
Like,
And one more fact that the deed which has been executed by the court is by a dead person. Kishore Prasad Gupta is now dead in 2019 and that is their petition itself. They enclose the deed which has been executed by the court in the execution case. They have enclosed the deed. Your Lordship may kindly see the person who has executed is Kishore Prasad.
on behalf of him.
Yes.
कोई नहीं है, कोर्ट कोई नहीं आता तो किशोरी प्रसाद या कोई नहीं आता तो कोर्ट. किशोरी प्रसाद डेड. डिफेंडेंट नंबर 3 नहीं है वहाँ. Because of that, Lordship has already observed. Now section 20 specific relief.
Ready?
The jurisdiction to decree a specific performance is discretionary and the court is not bound.
कौन सा सेक्शन पढ़ रहे हैं?
Section 20 Specific Relief Act 1963.
Substituted performance of contracts.
Discretion as
Specific Relief Act
1963.
सेक्शन कौन सा पढ़ रहे हैं?
Okay. Specific Relief Act. Section 20.
आप कौन सा साल का किताब है सर आपके पास? इनको जरा दीजिए किताब. भाई हर चीज का 2-3 किताब रखा है. दीजिए उनको. ये दीजिए.
यहाँ पर निकाल नीचे से. लीजिए सर.
किशोरी प्रसाद गुप्ता का तो डेथ हो ही गया है, तभी ना सब्स्टिट्यूट हुए हैं.
हाँ तो डिफेंडेंट नंबर 3 नहीं है कहीं.
डिफेंडेंट नंबर 3 कहीं नहीं है,
नहीं
मतलब उसको कोई डायरेक्शन ही नहीं है, उनका प्रेयर ही नहीं था.
एंड डिफेंडेंट है केवल. यस नहीं है, डिफेंडेंट्स नहीं है प्लेंट में.
नहीं देयर इज नो अमेंडमेंट.
Yes.
आपने जो 2008 में अमेंडमेंट किया था, व्हाट वाज द अमेंडमेंट फॉर इन 2008?
Para 20 of the plan, 21 लिखा था. 28. 28. I'm reading the language of the para 20A. In the plaintiff,
और रूबी देवी वाज डिफेंडेंट नंबर 2. ठीक है ना?
Ruby Devi was defendant number 2.
But the 20A you added 20A.
Yes. My lord, in the running page 7, it alert
20A, yes.
that the plaintiff, after coming in occupation of and possession of the suit premises, as stated herein above as absolute honor, he was delivered with possession of entire roof of the suit premises and plaintiff got
ये तो कुछ आपका उससे कोई मतलब ही नहीं है।
हाँ कोई मतलब नहीं
सेल
निकाला
डीड से कोई मतलब नहीं है, आप
इसका
कुछ
कोई
भी नहीं
मतलब
किया।
नहीं।
You may not have challenged the sale deed, but you should have amended your claim adequately and appropriately, which you have not done. ठीक है।
परसों हम साइटेशन दे देंगे मैडम
आप साइटेशन दे दीजिएगा ऑर्डर डिसॉल्व। देखिए ऐसे नंबर 5 ऑफ 2023 with respect to substantial question number 1, in furtherance to the arguments recorded on the last date, with respect to substantial question number 1, as framed by the order dated 2/8/2023, the learned counsel for the appellant has submitted that initially the suit was filed only against one defendant seeking specific performance of contract. Subsequently, the executor of registered sale deed dated 29/5/2006 was added as party. The purchaser was added as party. अच्छा दोनों लोग थे. As well as the executor of the sale deed, that is defendant number 3. Defendant number 3 were added as party. The learned counsel has submitted that though the sale deed was not challenged, as no prayer was made to set aside the subsequent sale deed, but even the relief portion was not challenged adequately. He has submitted that the appellate court, by decreeing by passing the decree, has directed the defendant number 1A to 1D to execute the sale deed.
and 7
And 7.
yes
कहाँ है 7?
judgment and decree
नहीं, 1A to 1D has directed the
and 7
and 7 भी है. कहाँ है?
copy of the decree
And 7 कहाँ है?
and the judgment also it is and 7
सर्टिफाइड कॉपी में तो नहीं है.
in the appellate court judgment certified copy it is there.
नहीं.
नीचे में हाथ से लिखा हुआ वही है. डिक्री में हाथ से लिखा हुआ वो पार्ट है, वो तो वही.
In the judgment
नहीं, this is the decree. No, you are also described. That is the, ये डिक्री जो है वो अलग चीज है. डिक्री is a part of judgment in that, and he is referring the decree. उसमें quoted है लेकिन वो नहीं है. 7
ये and 7 यहाँ पे कहाँ से आया?
but in the judgment also my lord it is there well and 7 by hand it is mentioned my lord in the total portion amended quite
Amendment हुआ बाद में. नहीं.
and 7.
सात बार जो है 22
देखिए,
Page 36.
how is it there? दिखाइए, दिखाइए हमको जरा। ये मिसमैच कैसे हो सकता है?
My copy, certified copy.
एप्लेट को दिखाइए। देखिए इससे कैसे मिस, देखिए तो मिसमैच है कि नहीं? और डिफेंड नंबर 7 कौन है? Who is defendant number 7? डिफेंड नंबर 7 तो कोई है ही नहीं।
I don't know, madam.
आपका फोटोकॉपी से नहीं चलेगा ना सर, हम लोग अपना सर्टिफाइड कॉपी मानेंगे।
हमारा सर्टिफिकेट कॉपी हमने दिया।
इसके current department. Defendant number 7 is the son of
Son of Kishori Prasad.
In the
If your
page
lordship-
number
8, your lordship may tell me that.
page number 8 minutes.
Page 8 of the brief.
पेज 8।
Yes.
Memo.
या मेमो हम
भाई
लोग
मेमो से थोड़ी चलेगा।
मेमो में जो ऑर्डर हम लगाए हैं जजमेंट, उसका पेज 8 पहला पेज जजमेंट का,
लाइक
अपीलेट कोर्ट के जजमेंट का पहला पेज।
अच्छा,
अपीलेट कोर्ट के
वो छूट गया लगता है। और सर्टिफाइड कॉपी में भी एरर।
वही हुआ होगा। यहाँ भी आया है संदीप कुमार गुप्ता लॉर्डशिप लिमिटेड, सिविल अपील नंबर 8 ऑफ 2020।
ये तो आपका है
हाँ,
ना?
वो
ये लीजिए, हम अपना रिकॉर्ड से लेंगे, हम किसी दूसरा का रिकॉर्ड नहीं करेंगे।
कोर्ट का रिकॉर्ड दिया।
कोर्ट का रिकॉर्ड दीजिए।
अपीलेट कोर्ट का जो पहला पेज है ना,
हाँ,
यस, फर्स्ट पार्ट जस्ट आफ्टर मेमो, फर्स्ट पेज है
हाँ,
जी। उसमें देखिएगा ऊपर में रितेश कुमार गुप्ता है। रितेश कुमार गुप्ता इज दी अपीलेंट
रितेश कुमार
Yes.
गुप्ता इज द एप्लीकेंट।
वर्सेस,
हाँ,
उसके नीचे में देखिएगा लास्ट में
अच्छा, लास्ट में से
हाँ, संदीप कुमार है लॉर्डशिप। ये सब्स्टिट्यूटेड है किशोर के बेटा। ऊपर में बेटी को बनाया है ABCD, उसके बाद ये बेटा को बनाना था ऊपर, लेकिन ये नीचे बन गया।
ठीक।
बस वही,
Excellent.
दैट इज करेक्ट।
Okay, the learned council has submitted that the deed was not वो plain was not amended लिखे ना। He has also submitted that accordingly the appellate court has passed decree directing the legal heirs and successors of the defendant number 1, namely Kishore Prasad Gupta, to execute the sale deed. Although the sale deed in connection with the same property was executed in favor of the defendant number 2 by the defendant number 1. He submits that if the considering the nature of relief prayed for is in the original suit, it was for the plaintiff to amend the plaint so as to get appropriate relief against the subsequent purchaser, namely Ruby Devi, but no such step was taken. बस इतना ही। The learned counsel for the respondent on the other hand, while opposing the prayer, has referred to the judgments passed by the Honorable Supreme Court in the case reported in bracket 1953 bracket close 2 SCC 509 para 40, 41 and 42. Then bracket 2022 bracket close 7 SCC 384 para 5.3 and 16, and bracket 2024 bracket close 8 SCC 83 para 20, 22 and 24 to submit that there was no need to challenge the sale deed, and therefore the subsequent sale deed was not challenged. Accordingly, the point of law framed as number 1 is fit to be answered in favor of the respondent. He has submitted that merely because there was no further amendment in the prayer portion of the plaint, the same is not fatal to the relief granted to the plaintiff, and in view of the aforesaid 3 judgments, the point of law is fit to be answered in favor of the respondent. So far as point number 2 is concerned, the learned counsel has submitted that there is no perversity in connection with the said finding, as the learned appellate court has held that there was previous partition amongst the family members. Correct? That's all? That's all? आपका भी हो गया?
जी, बस एक चीज वही था कि अगर आप the scrutiny court has gone beyond the decree of the appellate court. They have scrutined.
अभी executing court का हम लोग क्या ही बात करें?
Consequence उसका होगा ही.
The arguments are concluded. Short synopsis with respect to the arguments which have been advanced in the open court be filed by the parties by day after tomorrow. At this, the learned counsel for the respondents has submitted that he may add 1 or 2 judgments for consideration. इसको जजमेंट के लिए रखिए तो किसी मेरा चार्ट Pose this case for judgment on 5th of March. ये सौरभ जरा देखिएगा कि कौन है फ्री, मध्य उतरेंगे हम दिखाएंगे. कोई चीज़ की ज़रूरत हो तो विनीत जी को फ़ोन करेंगे, चाहे सुब्बत जी को फ़ोन करेंगे, है ना? कहाँ है वो?
रेलवे हॉस्पिटल
रांची में.
Specifics case serial number 21 AC 85 51.
पास ओवर था, आपका है आपका 25 नहीं, ये ना इसमें ऐसे एंट्री करते हैं हम लोग। ऐसे नंबर अभी कौन सा डेट हमने डाला है, 5 मार्च को, 5 को डाला है ना, 25। ऐसे नंबर बताइए।
Essay number 5 of 23.
5 और
23.
23। आज डेट कितनी है?
20th of January.
ये सारी एंट्री अपने करके रखते हैं।
Yes.
और जहाँ तक वो हम लोग जजमेंट का डेट यहीं से देखते हैं, ऑर्डर नहीं रहता।
Serial number 25. Essay number 134 of 23.
हाँ बताइए, अकॉर्डिंग टू यू व्हाट ऑल आर द मेन पॉइंट्स फॉर कंसिडरेशन? जस्ट हाँ, सीधा सब्सटेंशियल क्वेश्चन ऑफ लॉ पर आइए। ए बताइए।
Substantial question number D is suit was for
Just a moment. So you are placing D. The pencils which happen. Okay. This is whether the, can you read it?
this is whether the red appellate court while passing evening judgment failed to appreciate and primarily for recovery of possession based on the right by the giftee, which has no sanctity and suit was not maintainable and barred by limitations. My contention is that initially they have filed a suit for recovery of possession on the basis of the gift, on the ground that there is a relationship of landlord and tenant. That to that the trial court has given a finding that there is no trial court, no relationship between landlord and tenant. If so, primarily their case was for landlord-tenant relationship, which itself was not maintainable. And if they are relying for recovery of possession on the ground that they are having title, in that view of the matter, the limitation would be 12 years.
Claimed title.
They are
Right, by
claiming-
virtue of this deed, gift.
Gift.
No, this property belonged to their ancestors also.
This property belongs to one Juman Mian.
That's right.
Their case is that
Ancestor of the donee. Correct?
yes, they claim so. They say
You also don't dispute it. It is not in dispute.
our case.
You are saying that there was a pacha.
My,
But the fact that the property belonged to the ancestors, that is not in dispute.
property, so far as the property is concerned, the original recorded tenant was Juman Mian.
Yes.
As per them, he inherited the property. He inherited the property, and subsequently.
You tell us, as per you, what is the case?
My case, Your Lordship, is that Juman Mian has allowed me to construct house
When?
more than 50 years back.
So your case was that you were in permissive possession.
I was permissive possession of Juman Mian. And my specific case is that there is no relationship of landlord and tenant. And their case is that there is a relationship of landlord and tenant.
Yes.
That too after when the sale was made in the favor of the vendor of the domain. But no rent receipt was brought on record. And neither the vendor of the donee nor the donee. And ultimately, there is no delivery of possession, either physically or constructively. So that part is a illegal part, and for that part, that finding is a perverse finding by both the courts. Because in Mohandam law, even if it is a registered deed, there
Either
are
constructive or actual.
in the Mohandam law, the gift is three. There are three ingredients of gift. 149 of Mullah.
You see, there is a finding that you were under permissive possession.
Of human being.
Yes. And then the court says that once you are in permissive possession, you cannot claim adverse possession.
That finding I will also show below.
Show that one.
Yes.
Because there is a finding that you were in permissive possession. There is a finding.
But I was in illegal possession.
No, permissive possession.
The illegal
No.
possession.
No.
My document is.
No, you forget about your document. We are on the findings. You just see. Internal page 9 of the appellate court statute. Issue number 6.
Para 15.
Yes.
Whether the suit is barred by principle of adverse possession.
Yes.
The case of the appellant before the court is that he was inducted in the suit by original right, who subsequently sold the suit land to donor, and the defendant appellant nowhere stated when his possession of the suit became adverse, and it is a settled principle of law. Who seeks title on the ground of adverse possession must prove that when his possession becomes adverse, but a defendant appellant failed to prove his adverse possession. Apart from this, the case of the appellant, he was indicted by the original right, and thus the appellant is in permissive possession. My case, Your Lordship, that one way back 50 years back.
No, whatever be your case, we have to decide the case on the findings recorded.
Yes.
Yes.
So far as the plaintiff is concerned, plaintiff's main case is that he is claiming title by virtue of the gift deed.
No. You see, plaintiff is claiming that there is a gift deed executed in her favor by her father-in-law.
For the father.
Father-in-law.
Father.
Otherwise, also she is entitled, irrespective of the gift deed. Because the title may flow on her.
May not be.
Yes.
May not be. As because.
You don't have any registered deed in your favor.
No.
From Jumman Mia.
No.
You are not claiming through Jumman Mia except that you were in permissive possession.
Yes.
Right?
Yes.
And these persons, they are claiming through Jumman
No,
Mia.
there is an additional point also. During the pendency of the proceeding, not during the pendency, but rather in the 1994, a Bakshit Parcha, after very proper year, it was granted. And they have brought it on record by way of an amendment, without pleading a state as a party. And they have also preferred a revision before the Deputy Commissioner. Deputy Commissioner did not quash my Parcha. So I am in possession, and there is a Bakshit Parcha also in my favor.
That possession is from 1994.
No, that position is way back from 50 years back. That is the ground they have taken.
How do you say you
No, that
you
is
are
the
shifting?
document.
You are shifting from permissive possession to possession by virtue of basket purchase.
No, I am saying that I was permitted by Juman Mia, and actually the main person is the Juman Mia. And after taking it,
So therefore the court says that what is the date, from which date are you claiming adverse possession? These foundational pleadings are not there in your written statement.
my written statement, there are pleadings. But the question, Your Lordship, which I want to put forth, that so far as the possession is concerned, my possession is established. There is no doubt.
There is no
There is
doubt.
doubt about it.
Whether it is an adverse possession is not
The
or
question.
not is the question.
Question that will come later on. Unless the plaintiff has a title, and if the suit is not barred by limitation.
Plaintiff has a title because plaintiff is ultimately the descendant of the recorded tenant.
No,
No means?
They are not. They are not the recorded tenant. They are the recorded tenant as per them. The son of the recorded tenant had transferred the property in the name of the Sahzada.
So they are claiming by virtue of
But question-
registered deed executed by the son of the recorded tenant, right?
Yes.
In the year 1961 or 64.
These are all paper transactions. I am saying so because despite I was in possession, just to create evidence, these sort of documents are
In
happening.
1961-62, they created a document. Sale deed is of 1961-62.
Deed of 1961.
Yes, so they
But-
created, they anticipated.
But the question is, but might not make any question. He did not take any action.
And gift deed is of the year
Gift deed is of 84.
84. So
Four.
after how
And-
many years?
And suit has been filed in the year. Suit is of 95. Suit is of 95. And the cause of action was when mutation was rejected, when their mutation was rejected, on the ground that we are in possession, and that too our possession tracks back to last 50 or 60 years. On this ground, it was declined.
What is the finding of the learned trial court with regard to your adverse possession?
All 3, 4, 5, 3, 4, 6, and 7. It is issue number 3. Issue number 3 and 5 finding is on internal page 60.
16.
It has not discussed that way, only on the Bakshit purchase. And appellate court also taking into consideration that the cause of action by virtue of amendment has said that the suit is not barred by limitation.
That's all. कुछ नहीं
And the main point, Your Worship.
आपने सुन लिया.
Main point, Your Worship. Plaintiff has not been incoming in this case. Plaintiff has not been there. I am relying on a direct judgment of Supreme Court that plaintiff is required to be done.
Plaintiff was very old,
What? That she
and
was.
that was the reason the
No,
plaintiff
but
was
in this
not
particular
assigned.
case, it is essential, and because they have not examined donor, and they are claiming property by virtue of gift deed, and gift has not been proved in accordance with law. That gift
You forget about it. But the point is that the purchaser of the property by virtue of sale deed in the year 61-62, she is the daughter-in-law of the purchaser of the property.
But the question, Your Worship,
Irrespective of the gift.
that is not their case. Their
That is
case, their
maybe,
case-
you see, maybe that their case was that father-in-law gifted the entire property.
No, I am saying so.
That is
because-
their case.
I am saying so because in Mohandam law, she may not be the only sharer. In
Nobody
Mohandam
has
law, there can be
objected. You
so
don't
many
need to worry.
sharers.
Are you a relative?
But-
No.
No, I am not a relative.
You are a third party, no?
I am
You
a
don't
third
need to
party.
worry about others who could have claimed. We don't bother about it.
The question is that a plaintiff has to prove his own case.
We'll see.
Plaintiff has to prove his own case. And their initial case was a landlord-tenant relationship, which they left. And the suit is admittedly barred by limitation. I am in possession of the property. I'm in possession of the property. The gift has not been acted upon.
हम सुन लिया, आपका कोई भी सबमिशन नहीं छोड़ेंगे आप, निश्चिंत रहिए. Second appeal number 134 of 2023. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the plaintiff had
बातचीत पता तो जो हमारे पेपर में है, उस
the
पॉइंट पे तो लॉ है, इस पे हमारे पेपर में लॉ.
learned counsel for the appellant has submitted that the plaintiff was claiming the property by virtue of gift deed. Registered gift deed number 1760 dated 16/2/1984. Exhibit B. But the gift was not complete in terms of the Mohammedan law in view of the fact that the property was never delivered to the plaintiff. He has also submitted that the defendant was in possession of the property
Since 60, more than 60.
since more than 60 years. The learned counsel has further submitted that the suit was filed alleging that the defendant was a tenant under the recorded Rayyat, namely Jumman Mia.
No, they are claiming that I am a tenant of the vendor of the doggy, Sajada.
Okay, she is by claiming that the defendant was the vendor of the doni. Yes, the defendant was the
Tenant of
tenant.
Sajada.
Sorry,
Sajada, who is putted gift.
the defendant was the tenant under Sheikh Ahmad Ali Ansari, who was the donee with respect to the gift.
Who was done.
Oh yes, who was the donor with respect to the gift. But and accordingly, the suit itself was not made.
And barred by limitation.
He has also submitted that the suit was barred by limitation as the defendant was in possession of the property. The learned counsel has also submitted that it has come on record that the appellant was issued basket Parcha in case number 3 of 1994-95 by the circle officer, and the circle officer or the deputy commissioner were not made party in the proceedings. He has submitted that the legality and validity of the basket Parcha has been entered into by the learned court by denying relief to the defendant, by observing that the necessary procedure etc. was not followed.
Which is barred under section 18.
The learned counsel submits that such a proceeding is barred under section 18 of Bihar
Privileged Person Homestead Tenancy.
Bihar Privileged Persons Homestead
Homestead
Tenancy
Tenancy
Act. The learned counsel submits that in the landlord-tenant relationship has been ultimately held to be not established, and the
No finding of the appellate court on that.
as per the finding of the learned trial court as well as the appellate court, and the defendant was found to be in permissive possession of the property. The learned counsel submits that considering the fact that the defendant was in possession of the property for a long period, therefore the judgment passed by both the courts have failed to consider that the suit itself was barred by limitation. And the point of adverse possession has not been properly considered by both the courts.
Gift is also not acted.
The learned counsel submits that neither the gift was acted upon nor the courts have properly considered the point of adverse possession, and therefore the substantial question of law arises in the present case for consideration, in spite of concurrent findings by both the courts. That's all. While giving the background, the learned counsel has submitted that the land originally belonged to one Jumman Mian, and then his son was Ismail, who sold the property by 2 registered sale deeds.
That is there, yes.
हाँ.
That is the case only.
वो तो एग्जिबिट हुआ है ना सेल डीड,
Poor.
हाँ, तो उतना तो आपको एडमिट करना पड़ेगा ना. By 2 registered sale deeds in favor of Sheikh Ahmad Ali Ansari, by registered sale deed dated
It is 15/5/1961.
15/5/1961 and
16 January 1964.
and 16/1/1964.
It is exhibited document 4 and 4/.
Exhibit 4 and
4/.
4/1.
A.
4/A. To Sheikh Ahmad Ali Ansari, and as per the case of the plaintiff, Sheikh Ahmad Ali Ansari gifted the property by way of registered deed of gift to the daughter-in-law, who was the plaintiff before the court. He has submitted that at no point of time the donee got possession of the property.
Neither donee nor the donor.
At no point of time, neither the donor nor the donee got possession of the property. And therefore, the defendant had perfected his title by way of adverse possession. Okay? For judgment, they are to arguments concluded.
There are some judgments.
बस हो गया, सुन लिया.
The judgment will define.
बस अब सुप्रीम कोर्ट में जजमेंट लिखेंगे. अब सुन लिया, अब आपका कोई कम तो नहीं सुने, 1-1.5 घंटा सुने. ऑर्डर लिखाने के बाद कोई जजमेंट नहीं. ये गलत तरीका ही गलत है ना?
Parcel of cases serial number 20. Serial number 63 of 2021.
Yes.
Mr. Vijay Kumar.
बताइए. कहाँ कॉम्प्रोमाइज किए हैं?
पंचायत
इसमें तो इस केस का कोई जिक्र ही नहीं है.
खाता नंबर प्लॉट नंबर सब सबका जिक्र किया और तो डिस्प्यूटेड अंडर 81 डिस्प्यूट है.
देखिए, आपको अगर ये कॉम्प्रोमाइज को बाकायदा इसको लॉ का शेप देना है ना, तो आपको इस तरह से तो नहीं हो सकता ना.
नहीं, इसको हम फाइल करेंगे बाय एफिडेविट.
फाइल करने से भी नहीं होगा. आपको जॉइंट कॉम्प्रोमाइज फाइल करना
ज्वाइंट
है
कंप्रोमाइज करेंगे.
कि ये जो डिग्री को सेट असाइड कर दीजिए, हम लोग तैयार हो गए. यही करना पड़ेगा ना. आएगा, जलसा भेज देंगे.
नोट सर, हम फाइल करवा दें 2 वीक्स टाइम दे दीजिए.
कहाँ की पार्टी है?
चतरा करिए.
देखिए, ऐसे नंबर 63 of 2021. The learned counsel for the appellant has submitted that this second appeal, that there may not be any occasion to decide the second appeal on merits, in view of the fact that the petitioner and the respondent have entered into compromise. He has submitted that notice may be issued to the respondent so that appropriate order may be passed. He has also submitted that some proceeding has, itna hi kafi hai. Issue notice to the sole respondent through the concerned police station, for which requisite be filed by the appellant by Monday. Post this case on (11th of February) in the supplementary cause list, awaiting service report. उसको अब वापस इसको रहने देते हैं यहाँ पर. हाँ?
Serial number 21. Case number 85 of 21.
May please your lordship.
हाँ बताइए.
This is my lords, the plaintiff's second appeal against the judgment of affirmance. The plaintiffs and my lord the defendant numbers 4 and 5. They are my lord the descendants of the recorded tape.
Just a moment.
We are concerned with Schedule B property, my lord, which is 17 decimals of land.
Just a
Lord.
minute. Let me just note down. Plaintiff is the appellant.
Lordship.
वो जो अभी हमने परसों के लिए रखा है ना.
Yes.
Yes, plaintiff is the appellant.
Lordship.
Suit dismissed.
Suit dismissed. Confirmed, my lord, in appeal.
That's right.
Affirmed in appeal.
Defendant is the.
Lordship.
Defendants are the.
The private, my lord, defendant number 4 and 5, they are, my lord, plaintiffs, and defendant numbers 4 and 5, they are the descendants of the recorded claimant. Suit was filed, my lord, for declaration of title and confirmation of possession in the alternative for recovery of possession with respect to the lands, my lord, measuring an area of 17 decimals appertaining to plot number 51 of Khata number 19, situated at village Chauparan, Tola Nawati, in the district of Chakra. Now, lordship, the specific case of the plaintiff is that, my lord, the lands measuring an area of 34 decimal, which has been mentioned in Schedule A of the plain, was recorded, my lord, in the name of one Janki and Sukram, both sons of Tejo, having one equal share, and my lord Lalo Mahato, son of Kapoor Mahato, having one share. Khatian, Lordship, Provisional Survey Khatian has been exhibited. Now, Lordship, Janki, one of the recorded tenant, gifted his share, measuring an area of 8.5 decimals, Lordship, for construction of hospital.
50%.
Lordship, 8.5. Now, my lord, we are concerned with 17 decimals of land, which is fully described in Schedule B of
Including
the
this gifted property.
Gifted, Lordship, 8.5.
Including this gifted property or excluding
Excluding.
this?
Excluding. Now, my lord, we are claiming 17 decimals of land of
We
plot
means who is claiming? The plaintiff,
plenty.
the descendant of the recorded tenant.
Lordship, they are continuing in possession over
Who is disturbing your possession?
state, my lord,
State.
Lordship.
State is the party.
Lordship. Now, Lordship may kindly see.
Where is the state? State का क्या केस था?
State, Lordship, state का केस है कि the land was acquired in the year 1922. But, my lord, no document has been filed that the entire suit land was acquired in 1922.
तो फिर कैसे आपका केस डिसमिस हो गया?
डिसमिस हो गया कि हम जो रेंट रिसीट फाइल किए उसको कोर्ट डिसबिलीव किया और हम एडवोकेट कमिश्नर का रिपोर्ट भी है कि वी आर कंटिन्यूइंग इन पोजीशन, ये दोनों को डिसबिलीव करके वो बोलते हैं
Read the written statement of the state. यहाँ पर ऑर्डर से पढ़िए जजमेंट से. According to the plain we have seen, according to the written statement.
जी दिखाते हैं. अपीलेट कोर्ट का देखा जाए इंटरनल पेज 6.
कुछ नोटिस वोटिस भी नहीं दिए हैं स्टेट को.
नहीं नोटिस दिए, नोटिस बिना नोटिस के तो सूट ही मेंटेनेबल है.
वही तो.
सेक्शन 80 का नोटिस.
हाँ बताइए एपिलेट कोर्ट का जजमेंट. पेज नंबर.
पेज नंबर 6 देखा जाए. इंटरनल पेज 6.
हाँ 5 डिफेंडेंट्स. चलिए बताइए पढ़िए.
In this suit, there are 5 defendants, but the case proceeded ex parte against defendant number 4 and 5. While order dated 17/6/2014, the learned court below, but defendant number 1, 2, and 3 contested this suit. However, written statement has been filed only on behalf of the defendant number 3. Defendant number 3, medical officer, government hospital, Chauparan, stated in written statement that suit is not maintainable and it is barred by limitation and acquiescence, and it is also hit by misjoinder of party. It is contended that as notice has not been served under section 80 CPC and as such the suit is not maintainable. It is further contended that plaintiffs have admitted the possession of defendant number 1, 2 and 3 over part of the suit land, and the state started construction of compound wall on the suit land according to the statement of plaintiff. This is not an error of record. The plaintiffs have not admitted. Lordship may kindly see the certified.
You were seeking recovery of possession, no?
You
were seeking
confirmation of
confirmation.
possession, Lordship, in the alternative for recovery of possession. Lordship may kindly see, my lord, certified copy
So
of the
just a
plaintiff.
moment. This property is excluding the property which was gifted.
Yes,
So why this hospital was made by?
made by encroaching our land, Lordship. By encroaching our land.
ठीक है आगे बढ़िए.
Defendant further stated that for the betterment, security and the estate is legally entitled for compound work and any other construction, and as the state government acquired the suit land, and as such the plaintiffs have no right, title and possession over the said land. It is further submitted that after thorough inquiry and report, the land was acquired in accordance with law and due compensation was received by lawful and bona fide buyer. It is also contended that false statement has been made by the plaintiff that defendants are trying to remove the structure of the plaintiff from the suit land as there is no construction made by the plaintiff. Defendant has denied the knowledge regarding the fact that plaintiff are paying rent to the estate for the suit land, and it is stated that definitely a state rent receipt has been issued without proper inquiry. Now, Lordship may kindly see the rent receipt issued, my lord, in favor of the plaintiff has been exhibited which is evidence of possession. And it has been held by the first appellate court that rent receipt has been obtained by practicing fraud. What prevented them from filing appeal against the order, mutating the name of the plaintiff with respect to the suit land? And my lord, the lower appellate court has also held that the suit filed by the plaintiff is barred by limitation. My lord is aware, my lord, that according to Article 65 of the Limitation Act, suit for declaration of title and recovery of possession can be filed within 12 years. And there is a specific averment in the plain that, my lord, the defendant started disturbing the possession of the
बताइए
plaintiff.
क्वेश्चन ऑफ लॉ बताइए, अभी तो नोटिस नहीं हुआ है।
नहीं हुआ।
बताइए कहाँ है आपका क्वेश्चन?
If page 6 में हुई। और ये जो जजमेंट देखा जाएगा सुप्रीम कोर्ट का पैरा 8.2।
स्टेट का एडवर्स पोजीशन क्लेम डिक्लेयर करते हैं क्या?
अल्टरनेटिव क्लेम अब तो नाउ लॉर्डशिप द प्लेंटिफ कैन क्लेम एडवर्स पोजीशन आल्सो, लेकिन वो जो परमिसिव पोजीशन नहीं है हमारा, वो भी है क्लेम।
आपने बोला है कि एक्विजिशन का फाइंडिंग दी है।
नहीं, एक्विजिशन का फाइंडिंग है हुजूर, लेकिन एंटायर लैंड एक्वायर नहीं ना हुआ। हम तो, मेरा तो स्पेसिफिक केस है कि 8.5 डिसमिल जमीन गिफ्ट कर दी, लेकिन बाकी रिमेनिंग
एग्जिबिट कराए हैं।
हाँ, रेंट रिसीट एग्जिबिट है,
प्लीडर कमिश्नर का
रिपोर्ट भी एग्जिबिट है।
नहीं, रिपोर्ट एग्जिबिट है, डिस्कशन है।
हाँ है।
तो क्यों प्लीडर
कमिश्नर का रिपोर्ट को वो डिसबिलीव किए कि इनका कोई प्लीडिंग नहीं है कि पोजीशन में कंटिन्यू कर रहे हैं। हमारा तो स्पेसिफिक प्लीडिंग है।
देखिए सेकेंड अपील नंबर 85 ऑफ 2021 फॉर द लर्नेड काउंसिल appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the plaintiffs are the appellant before this court who have lost before both the courts. He submits that the plaintiff sought a declaration that they have absolute right, title, interest over the Schedule B property, and were also seeking permanent injunction restraining the defendant number 1, 2, and 3 or their men, agents, or servants from interfering with the possession of the plaintiff over the suit property. He has submitted that the plaintiffs throughout claimed possession over the property. He has further submitted that on notice the state had appeared.
Suit property lordship described in Schedule B.
Suit property described in Schedule B. He submits that on notice the defendant number 1, 2, and 3 appeared, and they claimed that the suit land was acquired. He has submitted that by virtue of gift, 8.5 dismil of land was given for the hospital, and the suit land was outside the gifted property. He has submitted that the pleader commissioner's report has also not been considered properly, though he was examined also, though it was exhibited.
Lordship, exhibit 6.
Examined किए होंगे ना, तभी तो वही तो अपना रिपोर्ट एग्जिबिट किए होंगे। though it was exhibited also as Exhibit 6.
Lords, 6.
The Learned Council has also submitted that the rent receipts issued in favor of the petitioner in favor of the appellant with respect to the suit property has also been disbelieved.
If the entire land was acquired, my lord, there was no question of issuing rent receipt. Lordship, this
We'll
is
see that.
Lordship.
The Learned Council has submitted that no document in connection with under any land acquisition pursuant to Acquisition under Land Acquisition Act 1894 was
1890.
produced.
Lordship.
He has also submitted that the learned courts have also misconstrued Article 65 of the Limitation Act. कौन सा बनाते हैं?
एक ही बना
F.
हाँ, केवल
After hearing the learned counsel for the appellants, this appeal is admitted on following substantial question of law. Page number 6 में है, point number F. Issue notice to the respondents under ordinary process as well as registered cover, दोनों लीजिए, for which requisites be filed by next Monday. Let the records be called for from the concerned court. Post this case on 27th February, awaiting service report.
Serial 21. Two cases pass over left.
पास ओवर किसका केस छूट गया? कौन सा सीरियल नंबर?
Serial number 22.
22 was passed over.
Yes.
Are you there? 22 तो शायद 22 कहाँ गए? आप पढ़ लिए? पढ़ लिया ही है. कितना पढ़े हैं तो कुछ बताइए क्या किए हैं? क्या केस है बताइए तो? फाइल बंद कर दे.
Now matter relates to a dispute between the parties of a land measuring area 4 decimals.
ट्रायल कोर्ट में आप कौन थे?
Trial court में plaintiff
ट्रायल कोर्ट में हारे की जीते?
जी
एपेलेट कोर्ट में क्या हुआ?
वहाँ पे appellants का हुआ था.
ओ रिवर्सल है, जजमेंट ऑफ रिवर्सल है. अच्छा, आपके सीनियर ने कौन कौन सा पॉइंट ऑफ लॉ बनाया है?
Whether the learned appellate court below committed serious error in the law in allowing the appeal preferred by the respondent. Whether the learned appellate court below failed to take into consideration that the appellants had valid cause of action for the suit. Whether the learned appellate court has failed to appreciate that the learned trial court has rightly held that the parties in dispute have separate mess, worship and cultivation. This is the dispute.
This is point number 3, right?
Yes, sir.
Then this is point number 4 is also 5. Sorry, point number 5.
Yes, sir.
Point number 7, correct?
Yes, sir.
Where is the appellate court's judgment? Page number बताइए. Finding
Page number 11.
Where is the point of determination? procedural number 10, point number 10, correct?
Whether the plaintiff has valid right title possession over the suit land. Page number 21, literature, point number 11, issue number 8 to 10.
Is there any discussion of the trial court's judgment in the appellate court's judgment? Have they discussed it?
Ladies and gentlemen, page number
16.
16 and 28, point number 16, where the issue number 8 and 9 have been dealt.
But there is no discussion of the trial court's judgment,
No.
although it's a judgment of reversal. Correct?
Yes, Your Lordship.
Correct?
Correct.
Essay number 101 of 2021. नाम बताइए अपना.
Pranav Kumar.
Sorry?
Pranav Kumar.
Pranav Kumar. For the learned counsel appearing on behalf of the appellant, the learned counsel for the appellant submits that the appellant is a plaintiff and the suit was decreed in favor of the plaintiff, but the appellate court has reversed the decree without discussing the findings and the reasons assigned by the learned trial court. He has submitted that the learned appellate court has not decided the appeal in terms of Order 41, Rule 31 of CPC. He has in particular referred to the substantial question of law framed the learned counsel has also submitted that the learned trial court clearly held that there was unity of title and unity of possession over the suit land, and the learned trial court has rightly held that there was no unity of title and unity of possession over the suit land, and there was no jointness in possession by the ancestors of the parties, and that they were in separate mess, worship and cultivation. But this finding has been reversed by the learned appellate.
Yes, sir.
Considering the submissions made and having gone through the impugned judgments, this second appeal will be heard on the following substantial question of law. Whether the learned appellate court has decided the appeal in terms of the provisions of Order 41, Rule 31 of CPC, while reversing the decree, judgment and decree of the learned trial court. It will be open to the parties to issue notice, admit, issue notice to the respondent number बताइए, to the sole respondent,
Yes, sir. Yes, sir. Sole respondent.
to the sole respondent, for which requisite in terms of speed post as well as ordinary process be filed before this court by Monday. Call for the records from the concerned court. Office to track speed post delivery, post this case for post this case on 27th of February in the supplementary cause list. हो गया, पढ़ लिए? अब ऑर्डर 41 रूल 31 पढ़ लिए, ठीक है? कहाँ से पढ़े हैं?
ICFI यूनिवर्सिटी
देहरादून, रांची में भी है, देहरादून में भी है ना?
हाँ।
फर्स्ट जनरेशन एडवोकेट, सेकंड जनरेशन,
सेकंड जनरेशन
हु इज द फादर?
हेमंत कुमार श्री हेमंत कुमार ही इज आर टेन वाट रामगढ़
बाकी बच्चे
23 one.
23 कौन है? Yes.
There are two appeals arising out of the same suit.
Yes.
That was, one is 34 of 2023 and the present one is the 49 of 2023. The first one has been directed to be listed on 4th of February. I was only saying that because their issues are interlinked, what may be tackled.
Second appeal number 49 of 2023. The counsel for the appellant has submitted that arising out of the same judgment, two appeals have been filed. The other one is second appeal number 34 of 2023, which has been directed to be posted on 4th of
February 2000.
February. Post this case on 4th of February to be tagged with second appeal number 34 of 23.
Okay.